go. Well, thank you all for coming. I'm Baron Soka of Tech Freedom. This is our first staff briefing here at our new offices, and I'm very proud to be hosting this with the Internet Infrastructure Coalition, I2 Coalition, represented by David Sneed here. We'll have lots more events coming up, including a COPPA event today, if you want to stick around for that. It's right in the next room. We also have an event on September 9th, which is the day that the DC Circuit will be hearing oral arguments on the net neutrality case. We're going to have a recap right after the oral arguments, and it'll be about 1 o'clock. And we're planning several other privacy and telecom-related events. But today we're talking about the one law on the internet that we really like, which is Section 230, which some people have gone so far as to call an anti-law. It's a law that immunizes, as you'll hear today, internet intermediaries like website operators and website hosts from liability for what their users create and send over their sites. So to tell you more about this, we're going to have a panel here today to walk through Section 230 and some of the proposals that have been made recently to change the law. We're going to record the event, and then for staff in the audience, we'll turn off the camera for questions and answers to have a more candid discussion. And having said that, let me just briefly introduce you to our panelists. Just to my left, your right, David Sohn at the Center for Democracy and Technology handles an array of speech and copyright and other telecom policy issues. Steve Del Bianco runs NetChoice, which is a trade association for internet companies, especially small companies. Professor Eric Goldman at Santa Clara Law School is one of my favorite law professors, and I dare say the nation's leading expert in internet law in general, and Section 230 in particular. He makes a point of blogging about every case that comes up under Section 230. And finally, David Sneed, whom I mentioned, representing the Internet Infrastructure Coalition, is a lawyer who counsels clients in this space and is going to tell us in particular about the interests of website hosts and all the companies behind the sites that you use and love. So let me just get started and ask you all to dive right into it. So what exactly is 230 and where did it come about? David, you want to kick us off here?
Sure. So Section 230 was enacted in 1996, and it was part of the Communications Decency Act, part of which was later struck down by the Supreme Court. But Section 230 survived as 47 USC Section 230, hence the name Section 230, and it was really born out of a concern that some case law had been trending in a problematic direction, where some internet content hosts were being held liable for the messages that their users were posting, and that was seen as a concern. At the same time, the host said, well, if we start trying to edit some of the content on our site, if we start trying to censor or control user communications, then all of a sudden it seems like we're too involved in creating the content of our user communications, and we might be held liable for any sort of malfeasance that those communications contain. So think defamation or any range of possible crimes or civil liability that could result from those kinds of postings. And in that kind of scenario, the concern was that content hosts wouldn't want to host user-generated content, they wouldn't want to build these platforms, and they certainly wouldn't want to exercise any kind of stewardship over their own sites, because they feel like if they dip their toe in that water, it would just increase the chance of them being held liable.
And this wasn't just a speculative concern. There were actually cases that had held that. You want to briefly explain the Prodigy case and the idea of publisher liability?
Sure. Maybe I'll let Eric do that one.
In 1995, there was a case that caught everyone's attention, Stratton Oakmont versus Prodigy. And Prodigy was a commercial online service. We don't have them really anymore today. But at the time, the idea was that service providers were going to build walled gardens that were going to be completely contained, self-contained, and that would include both the dial-up access to the walled garden as well as the content that would be available. And so Prodigy ran a commercial online service, provided dial-up access as well as published content, both that they originally originated, as well as that they obtained licenses from third parties, as well as user-generated content. In order to spur consumer demand for this commercial online service, they advertise themselves as family-friendly. In fact, my wife, who was a teen in 1990, had Prodigy. It was the kind of thing that her family felt safe using because it was designed to be a more safe environment for kids, as well as other services, but that was one of their marketing pitches. And a user posted in a message board on this commercial online service a post that was allegedly defamatory. It was about an investment bank and said that the investment bank was a bunch of crooks. The investment bank sued Prodigy for publishing this user posting. Prodigy said, hey, we didn't do it, their users did it, take it up with them. The court said, well, you advertised yourself as family friendly. You were trying to create a safe environment. And because you were doing that, you now take responsibility for the environment. Whether you did it, whether you properly policed the walled garden or not. And that's what caught everyone's attention and led to Congress wanting to get involved, was this concern that Prodigy was trying to do the thing that Congress wanted to do, trying to keep the online environment safe for kids, and the courts had punished Prodigy for doing so.
So how exactly does Section 230 work then, briefly?
There are two main operative provisions of Section 230. There's C1, which I'm going to summarize for a moment as websites aren't liable for third-party content. And then there's C2, which I'm going to summarize as saying there's no liability for filtering decisions. And we're not going to talk more about C2, I don't think, Baron, unless you want to. Always happy to. I love it.
Well, maybe David, if you just want to say a word about the importance of that so-called Good Samaritan provision. Anything beyond what Eric's?
Sure. I mean, that is what enables user-generated content sites to exercise some judgment and to feel that if they want to have terms of service, if they want to decide that their site is good for hosting certain kinds of content but not others, and if they want to just delete things that they believe are inappropriate, objectionable, that allows them to do it without fear of liability. So it really goes to the ability of sites to exercise some judgment, but in a loose fashion and without that amount of judgment that they're exercising, then making them liable for everything else on the site. So, I think if you look at any of the major user-generated content sites today, they do all have terms of service that specify that certain kinds of things are not allowed on their site, and they have the discretion to remove content that doesn't fit with their terms of service, and they feel they can do that because Section 230 makes it clear that they won't be liable for having made that decision and then have a content poster come back and say, no, my speech was constitutionally protected, therefore you had to keep it up on your site.
Or that they won't.
Failed to make one now.
Right, or that they won't increase their liability by virtue of doing some filtering, even if it's not perfect.
Yep.
So that's what Section 230 does. What does it not do? What does it leave open for law enforcement and for private plaintiffs to do? Eric?
So Section 230 tries to create a division of liability, and we divide the world into first-party content and third-party content. To the extent that someone is publishing third-party content, they're not responsible for it. But somebody is always the first party in that situation. Somebody is the originator of that content. And Section 230 doesn't touch their liability at all. In fact, it really tries to channel the liability. It says, go after the first party, leave the third parties out of it. So it doesn't touch first-party liability. It also has three exclusions that are statutorily codified. The first is for intellectual property claims. That's why we have, for example, the notice of takedown provisions for copyright. Those are because Section 230 didn't apply. The Digital Millennium Copyright Act came after the Communications Decency Act. It needed to then address something that was left open. Section 230 does also not apply when the claim is an Electronic Communications Privacy Act claim or state analog. And I don't think we're going to get to that any further. I don't actually understand that exception, and we've seen virtually no litigation interpreting that. The third piece is that Section 230 does not apply in the case of federal criminal prosecution. So if the Department of Justice wants to bring a claim, Section 230 is irrelevant.
And so that would be for what exactly?
Well, the statute specifically references things like sending child pornography is explicitly excluded from the statute, but any federal crime would be excluded. And so, for example, we've seen prosecutions or related types of activities by the Department of Justice related to illegal pharmaceutical sales and the advertising of that, as well as gambling advertising. And to the extent that those fit within the parameters of a federal crime, then Section 230 steps aside and the defendant can't say, but it was third parties. That's simply not applicable.
Okay, so the proposal that's been made, that some of you may have heard about,
There's one other thing it doesn't do.
please.
Want to cover that a little bit?
Sure.
So a local law enforcement official, a deputy AG, state official, might want to go after that first party that Eric described. But it turns out they need the help of the third party to find out who it is.
The intermediary.
The intermediary, the email service or the hosting service. So another thing that 230 doesn't do is it doesn't stop an intermediary from cooperating. When law enforcement shows up with a properly formed order or warrant, looking for the identity of a screen name that couldn't be identified, or looking for an IP address that was used in what law enforcement thinks was the commission of a crime. In those cases, intermediaries will do their best to cooperate. There's no implication that cooperating grants immunity. You look to 230 to grant the immunity. But cooperating is something that a lot of the ISPs do to try to make sure they stay on the right side of helping law enforcement go after the first party so that the third party isn't even implicated.
And I please, David.
And so I just want, without going too far into that rabbit hole, cooperation is not difficult. It is not that difficult for law enforcement to get that identifying information, given the way the law is written currently.
What's so interesting about Section 230 in my mind is that it gives service providers a choice. They can exercise a lot of editorial control over their site. They can exercise minimal editorial control over their site, and it's all the same. In the case of cooperating with law enforcement or setting up other voluntary screening mechanisms, the statute enables service providers to do so without fearing the liability that they might create. Just like they proudly advertise a family-friendly service, if these services decide that they want to create a more family-friendly environment or other environment that they've curated, Section 230 lets them do that without fear. And so it actually creates the precondition for more cooperative work with people who have concerns.
So let's unpack the big picture here, but before we do that, let me just emphasize, in addition to cooperation with law enforcement, it's also private plaintiffs that can, in fact, when they have a valid case and they have a legal process, can go to an intermediary in a John Doe lawsuit, and having convinced a court that they have a reasonable case, that, for example, an anonymous user has defamed them, can go to a court and say, I need a subpoena to compel the service provider to disclose identifying information about who this anonymous person might be, and that either identifies them or it allows them, for example, to get an IP address, which then allows the plaintiff to go to the ISP, the second intermediary, also protected by 230, to disclose the identity of that person so that litigation can actually proceed. So this is just a way of saying that Section 230 doesn't stop either law enforcement or private plaintiffs from going after the users, the so-called first parties that are ultimately responsible for whether it's criminal conduct or conduct that's simply illegal under civil law. So I want to talk about the difference between liability under federal law, which 230 allows now, and the proposal to allow intermediary liability under state criminal law. But before we do that, let's just unpack for us all, if you would please, why it is exactly that Section 230 is so important. What is it, practically speaking, that would happen if websites were suddenly held liable under, say, state criminal law for the conduct of their users? Eric, do you want to start here?
Just a few words. From my perspective, Section 230 has been the foundation of the user-generated content industry. We talk about Web 2.0. Web 2.0 is a response to the liability allocations that Section 230 enabled. In 2011, we had a conference celebrating the 15-year anniversary of Section 230's enactment, and it was amazing to see the different types of businesses that showed up at the conference, who were all building their business around this protection. There's the names you've all heard of, but frankly, in the Silicon Valley, we're much more interested in the names you haven't heard of yet, the companies that are emerging, that are trying to find a new market opportunity. You think about names that emerged just in the last 5 years, names like, say, Pinterest or Instagram. We don't know what the next Pinterest or Instagram looks like, but we do know that if they want to enable users to talk to each other, they're relying on the statute.
So Steve, what exactly does this mean for websites?
Yeah, consider the fact that you put up a website or distribute an app, it's instantly visible and available to residents of, well, everywhere. And that means that each of them thinks that their own local jurisdictions and laws protect them. And I know you all work in Washington, and we definitely have our hands full with two houses of Congress across the street. But there are 7,400 legislators in 50 states plus the district, AGs and governor's offices, 50 more of each. And the average year sees over 100,000 pieces of legislation in all 50 states. 100,000 pieces of legislation. Thankfully, they don't all become law, but it doesn't take but 2 weeks for a terrible idea to become a brand new law in the state legislature. The average number of session days per year, ready for this? 6,730 session days per year. So I got to tell you, compared to being a state government affairs rep, keeping your eye on Congress is like being on a summer vacation. It is truly a patchwork problem.
So
We have
it's
fix
hard
it
to
everywhere.
follow the laws, there's a lot going on out there, but practically speaking, so the risk of liability goes up. What does that mean for the site? What do they do that changes the world for users?
The sites themselves get pulled into court, and I was going to briefly discuss what we did in StubHub in North Carolina, where we did an amicus brief. StubHub's one of our members, he knows the distribute tickets. And practically speaking, what StubHub did is allowed people to sell tickets to events and concerts. They let you set the price. Well, it turned out that some North Carolina residents were setting a price above the face value of the ticket, and in North Carolina, that was violation of a law. So what StubHub found themselves was the trial court in North Carolina said it was StubHub who violated the law and held them liable for that. It took an appeal to the district court to get that overturned in 2012. But it meant that what the sites end up trying to do is to try to be as neutral as they can about implying what you can and cannot do on the site. If you're bringing together buyers and sellers, there wasn't always an eBay and Craigslist. It used to be if you wanted to sell something, you had to put an ad in the newspaper and hope that somebody would find it. But the internet brought together buyers and sellers, lower transaction costs, but it raises your liability if you do anything more than sort of say neutral.
So you're saying that site operators are afraid that some AG might decide that it wants their scalp
Yes,
and go after them. So that's what it means for websites and apps. David, what does it mean for your clients, for hosting providers and so on?
So for infrastructure providers, I'm going to piggyback a little bit on what Eric said about user-generated content. But honestly, for people who are the nuts and bolts of making the internet work, Section 230 has actually undergirded the internet as we see it. Really, Section 230 has allowed the internet to expand for any type of content and not just user-generated content. There are really 3 reasons for that. First is it creates certainty. The second is that it creates good internet citizens. And the third is it puts responsibility for content where it belongs. So the first in creating certainty kind of goes to what Steve says. It allows internet infrastructure providers to design compliance strategies based on a limited set of laws and based on their terms of service. So they get to design businesses that work for them. Second is it creates good internet citizens, simply because it really places the burden of determining whether a business is going to speak in a particular way with that business. And the third, that it places compliance where it belongs, is really that compliance with defamation, with these different types of laws that regulate content, belong on the internet, belong on the person who speaks, who is actually engaging in the speech, and not on the providers who are actually transmitting it. So that's how it really works for infrastructure providers.
And you and I were talking about this earlier, and you said that 68%, is it?
So there was a Loyola Law Review article that came out in 2010 that said that of the defendants who used this Section 230 as a defense, 68% of those defendants were infrastructure providers. So it's very clear that Section 230 has provided, it's a real valuable tool at protecting the way the internet is structured.
Okay, so bottom line, both of you, your cases, how does the world look different for users if that intermediary immunity goes away?
So I can be pretty strong on this point. It will create more conservative businesses that will design their businesses to only provide services to very certain types of internet businesses. There won't be any Facebooks. There won't be Pinterest, because infrastructure providers will be afraid that they will get called into court for someone's picture, for a statement that's made, so they just won't accept those businesses.
And that's particularly damaging for small startups. We're scraping together the venture capital and sweat equity to start a brand new concept who will run smack headlong into that wall of potential liability when it comes to raising money and getting advertising sponsors.
So
Small
people talk a lot
business is really
about,
tough.
killing the internet. Do you think that's an exaggeration or overstatement here?
Can I give one example which I think really hits the point home? I don't know how many of you use Twitter. I'm a huge fan of Twitter. Imagine Twitter with Twitter employee pre-screening every post before it goes live. That's kind of the way I think the internet would look. Yeah, you could have Twitter. It just would need every post to be screened, and Twitter's value comes in many cases from its immediacy. So scratch Twitter from the list.
So getting back to that original publisher liability concept that we were talking about earlier, sounds like you're saying that it's just fundamentally different for a newspaper to screen the letters to the editor that it posts from its readers. That's a far more feasible thing to do versus Twitter, as you say, having to do that same sort of screening for every single post that goes up.
Well, we get a bunch of new things from the internet that we've never seen offline. One is the immediate publication to a mass audience. Things like Twitter didn't really exist in the offline world. There really wasn't a way to do it, and the liability scheme might not have supported it. The other thing is that we get things like consumer reviews, another thing that didn't exist in the offline world, and we wouldn't have a robust set of consumer reviews in a different publication model because nobody wants to take responsibility for a consumer review that's negative if they didn't write it. In fact, people who wrote it don't usually want to take liability either. But no one's going to publish a negative consumer review for fear of defamation. So we just wouldn't have consumer reviews in the way we have them today.
So let me piggyback on that a little bit. Twitter doesn't charge users to use it. The reason Twitter doesn't charge is the internet essentially is very, very cheap. Internet infrastructure providers have built their businesses based on continually ratcheting down their costs. One of the things that pre-screening every post would do would be to require them to add employees and add features that would increase the cost to the point where ventures like Twitter probably wouldn't be able to get off the ground.
Or wouldn't be free, for sure.
Wouldn't be free.
And you would certainly get far less innovation in that space. I mean, one of the things you've seen in the internet precisely because the entry costs are low is new communications tools being built all the time. And if you now impose this liability threat, I think you'd see some of the user-generated content sites become much more heavily censored by the sites themselves. They do all kinds of pre-screening. They'd have to read all the users' communications first. Meanwhile, others would just never get off the ground because they simply can't devote the staff to pre-screening the large volume of stuff that comes in. And then I think a third category, there's lots of sites that maybe aren't even primarily a user-generated content site, but they allow comments. They have some features for interactivity. And this extends really to anything online that has interactive features and allows users to post comments or otherwise contribute to a conversation. All of those kinds of features, I think, would be at risk in a world without Section 230 because the sites would need to pare back on that to keep their risks and their costs low.
So David, CDT's slogan is keeping the internet innovative, open, and free, which I think is, or open, innovative, and free. I flipped the order, but we can disagree on that.
Right.
But they're laudable goals, and it sounds like the free here is both the free as in beer and also free as in speech. We've talked about the free as in beer. What about the free as in speech? What does 230 mean for users' free speech rights?
Well, the reason that the internet has been such an incredible boon to free expression, is not just because of the technical workings. It's because innovators are free to build new communications tools like Twitter, like Facebook, that become popular overnight and that draw huge amounts of users and basically makes it easy to empower users to communicate in new ways. And without Section 230, those would have to be much more locked down. You would not see the continued development of those tools, and the tools that exist would be highly censored. And I think the incentive for anyone offering a user-generated content tool in a world with a pared-back Section 230 is going to be to play it safe. It's just too risky to have an open door to user-generated content if that makes you potentially liable for a broad array of state or local laws that as Steve mentioned, it's hard to even catalog or keep up with. So I think what you would see is just many fewer opportunities for technologies that empower user speech. That in the end is terrible for free expression. It also means that those conversations that occur online on the platforms that continue to exist will be heavily censored. The companies will be playing it safe, and anything that is controversial or that they even think somebody might object to would likely be taken down.
So Steve, what about international competitiveness here? What is Section 230's role been in helping American businesses lead the internet?
I know it really does amaze our competing economies in Europe and Asia, but they are continually astonished at how an American company can begin a business model with no revenue stream. They can actually attract eyes, attract viewers, posters, people that post videos or photographs by building a community that wants to communicate with each other through some of the innovative tools that David and Eric have discussed. And we're able to do that because at some point, the ventures can monetize. They can actually begin to advertise to those people or charge for premium services the way that LinkedIn did and others. And platforms can begin to charge commissions for transactions the way that eBay and Amazon do. But all of those monetization of audience can't be done in legal regimes where there's potential liability for the violation of commerce laws or the violation of defamation laws. But the only way to build a massive audience is to be able to have the content that attracts both the users that post and the users that read.
David, CDT's done really good work in this area comparing internationally the way these regimes work. Could you briefly summarize that?
Sure, we did a paper back in December that takes a broad look globally at different approaches to intermediary liability, and there are a range of approaches. And Section 230 is pretty much the strongest approach in terms of providing immunization to intermediaries for third-party content. That's the strongest model out there, and it's a uniquely successful model. I think it's no coincidence that the big user-generated content platforms have tended to be developed in the United States. We've been the hub of all that economic activity precisely because we have a legal regime that is favorable. We've had other countries have taken different approaches at times. There was a case in Italy that got a lot of attention where some Google executives were charged with criminal conduct based on videos that users had posted. There's been a similar case in Thailand. Other countries often don't get the idea that the platform should not be responsible for what the users do. As a result, we are primarily the place where these platforms get created and launched.
And to be clear here, we've been talking about liability for the platforms, but you just alluded to the fact that at least in some countries and some laws, that liability can actually be for the corporate executives. So those people could actually be facing prison time if the site doesn't do a perfect job of catching every piece of user content. So that I think is really the key understanding why criminal liability is so dangerous for sites and so causes them to change their model. So David?
So I wanted to kind of roll this up a bit. The Section 230 really reinforces the U.S. brand as having a hands-off and a very accommodating legal climate. For infrastructure providers, for most infrastructure providers, between 50 and 75% of their customers are non-U.S. customers. And the reason for that is the U.S. has two things. One is a relatively inexpensive infrastructure, and the second is a regulatory environment that actually encourages internet businesses. And Section 230 really reinforces that in the best possible way.
So, let's talk then about why some people want to change 230. There's a perception among some people that, especially in Europe, that the internet is a lawless land, and that we have to do something about it. So is that true, Eric?
So back in the 1990s, there was a lot of speculation about how the existing laws would apply to the internet. And so at the time, I think there was some thought that it was a little bit like the Wild West. Everyone knew there was some law somewhere, but nobody quite knew which laws applied to specific conduct, and we had to sort that out. That's obviously changed a lot. As Steve mentioned, we've got these manufacturing machines, both here in DC and at every state capital, manufacturing lots of new laws every year. And those laws, in many cases, are focused on the internet. People love to think about how they can intervene to improve the internet. And as a result, the internet now is subject to heavy regulation. In fact, when I teach internet law, I tell my students, it's a statutory course. In the 1990s, it was mostly a common law course. It was mostly about cases and how they might extrapolate. Now it's about, look at all the statutes that the federal and state governments have put on the books that apply to the internet. So the internet is, even if it was true in the 1990s, it was a little bit of a Wild West thing, that has long since changed. We are definitely navigating through very thick regulation today. And don't forget that in many cases, the real law of the internet is the service provider's own internal policies, the policies they adopt through their terms of service or other internal guidelines. And we've seen the incumbents, the major players in particular, become very aggressive about setting up their own standards of what kind of behavior they will tolerate. So it's not a lawless land either in reality, but also as a de facto matter. We've seen a lot of movement towards trying to get to the right social balance.
Okay, so self-regulation sounds like not a compelling thing to a lot of people, but why does it work here? Well, why do sites actually and hosts actually have an incentive to clean up content at all? Are they just doing this out of the goodness of their hearts?
So from an infrastructure provider, this allows them to create the businesses that they want to have. It also allows them to have a very productive relationship with their customers. It really is having the ability to say to customers and talk to them about what their businesses are doing really establishes a great customer relationship. And the third thing that it does is it allows them to balance compliance costs with their business needs. So self-regulation is probably not the right word for it. It's actually contract negotiation and contracting with the businesses that people who have new businesses want to engage with.
And Steve, what role do advertisers play here in giving sites like Facebook an incentive to clean up content to the extent they can?
Yeah, we've seen that not in a proactive, prospective way, but in a reactive way. In that when a particular group feels that they've been offended by user-generated content on a site that doesn't police, it's amazing how much pressure they can put on the advertisers who underwrite that page and that site. And advertisers have been quick to come in and force a company to change its terms of service, to remove pages that were offending. And all this happens outside of any defamation lawsuit or action by an attorney general. But advertisers do have quite a bit of sway, quite a bit of leverage over the sites to affect their policies.
So Eric, there's been rumblings among some people. Section 230's had its discontents among some academics. What have they proposed to do? And why is it not a good idea?
Every law creates winners and losers. Section 230 does as well. And so there are always people who are on the losing side of a piece who would like to see it different. We have not seen any real concerted efforts to change the basic structure of 230 since the beginning. It's 17 years old now. Am I doing my math right? Over 17 years old. Its basic structure has remained untouched and frankly has not really been seriously challenged. But there are a lot of pet interests, particular people who say, Section 230 is great, but I got a little thing, could I just do this? And I don't actually know if it's a true Yiddish term, but we sometimes talk about schnibbling, where you take a little piece of paper and you start cutting up into little bits and you get all this confetti. And so there's always the risk that
Write that down.
I don't know, maybe we made it up. That's what we talk about at our house, because that's what my kids do, they make a whole mess. Anyway, there's a risk that section 230 will be schnibbled. Can you get that into the record there, Baron?
I'm already on the hashtag.
That everyone's got their little pet interest. It says section 230, but, and that's really, I think, been the big concern. And I think David really hit the nail on the head when he talked about the certainty that section 230 has provided. That what section 230 has done is it has channeled the amount of law that the companies need to try and master without trying to, without limiting the fact that there's a lot of law they still have to consider. So the purity of section 230, of limiting the exclusions that it has actually been one of its biggest strengths. And so every time we hear the discussions, but I have my little pet interest, it really comes back to, wait, every pet interest you have is going to be another place where people are going to try and push as much into it as possible because they're unhappy with their special interest.
So, but section 230 has been amended twice. What's wrong with schnibbling it now?
Well, there's been 2 amendments to section 230 in 17 years. One was an addition to section 230D that basically is a mandatory disclosure thing. That's supposed to tell parents that they can go get tools to protect their kids. You guys may have seen this language. Compliance is abysmal. It's a very dated notion. People kind of already know that they can go get protection for their software to protect their kids. The other amendment was in 2006 as part of the crackdown on online gambling. There was a specific exclusion, section 230, that certain entities would be subject to a civil order as part of a DOJ crackdown. And so we've seen no action in that area. It's not come up. We do know that the DOJ does have online gambling as one of the things that it does pay quite close attention to.
Now, so, but that experience, that was one way to deputize intermediaries. Why do you think that worked? Why didn't that break the internet in a way that making sites liable under state criminal laws would?
In the end, in part, it's because I believe that it's limited to part of a DOJ effort, and so we put a lot of discretion into the DOJ about what to bring, what cases to bring, and we hope that they exercise it wisely. But the real risk is when we allow a larger number of enforcement actors, whether they are state or local prosecutors or private plaintiffs, to take advantage of exceptions. We see a lot of action when we expand the universe of enforcers.
Any other thoughts on this idea of state criminal liability being particularly problematic?
You know, I can give you one story. We publish the iAwful twice a year. iAwful, Internet Advocates Watch List for Ugly Laws. Look at iAwful.com.
It's a good list.
Yeah, it's 10 worst.
It's a good list in a bad
in a bad way.
You want to give a Facebook dislike to it.
Exactly. So just recently we had a bill in Ohio, a cyberbullying bill, because a lot of states did react. State legislators react to the idea of cyberbullying is a big problem. The way to stop it is to affect the internet. And they would have made it a crime to use a web page or blog to cause emotional distress to an Ohio resident, even by posting or tweeting an insulting statement, whether or not it is true. So making that a crime and giving a state law enforcement the ability to go after the intermediary who posted the comment is exactly what we needed to focus attention on. We were able to show that it would, of course, be blocked by, the immunity would be provided by a 230, but the key thing to do was to just stop the law. And fortunately, with the help of Eric and others and putting it on the iAwful list, we were able to defeat that. But it's a constant play of whack-a-mole to stop these bad bills as they rise in the states, and states are very quick to add criminal penalties to civil items, wanting to say that they need to protect their people from bad people and bad pictures.
I would say one other small point in response to your question is, first, as you pointed out, criminal liability is a very serious thing for entrepreneurs, right? I mean, they may be willing to take some risks with how some court cases will come out on civil liability that might pose a financial risk to the company. Criminal liability is actually about potentially going to jail, and it's going to be very hard for entrepreneurs in that kind of scenario to take the risk to actually launch a new site. And then second, if you had an exception that was for state criminal actions generally, at that point I think you have something of an invitation for anyone who is frustrated with some aspect of Section 230 to try to craft a criminal statute that gets in whatever their pet cause is. So it ends up, I think, being more than schnibbling. It ends up being kind of a blanket statement. State criminal issues are exempt, and then all states have to do is shoehorn things into criminal statutes. So I think it's sort of an invitation to states to criminalize whatever behavior it is that they want to schnibble about, and so you get a lot of that. So I think it's actually a fairly broad exception, if you have an exception like that.
But to be clear, today, if there is an issue, Congress doesn't need to amend section
No.
230. All they have to do is deal with the problem under criminal law. And Steve, why do you think that's a better approach than simply leaving that to the states?
Because internet websites, apps are instantly visible to everyone. And as it turns out, not every state agrees what's criminal. In fact, a lot of the controversy over Backpage is legal activity, adult-to-adult interactions that are illegal in many states. So it's insane to allow a single state law to govern sites that are visible to citizens of every state. We rely upon Congress then to draw this notion of consensus as to what is criminal on a nationwide basis. Unfortunately, we don't do it very frequently. Yeah, I think you said the gambling was the most recent addition, but the idea of letting that bubble up to a national consensus is far better than a state patchwork.
So, Eric, briefly, what's the con law on that? Is that insane, or is it insane and unconstitutional?
So, my own personal position is that states have no role of regulating the internet, period, because we don't know how to build tools cost effectively that respect state borders. There's not very good geographic authentication at the state level or lower, and then it becomes incredibly costly to try and do more accurate authentication. So when we do things online, we don't know which state we're dealing with, and so states trying to impose their own will on the internet have either forced people to try and do the authentication, or they say, we don't care about the authentication, you need to, across the globe to comply with our laws because you can't figure out when you're dealing with us or not. And so my position is that all state laws attempting to regulate the internet violate the Dormant Commerce Clause, which is the backside of Congress having exclusive jurisdiction over interstate commerce. Of course, I've not seen it as aggressively as I have, but we see a lot of state laws struck down by the Dormant Commerce Clause, and as well as the First Amendment, and in many cases as well under Section 230. And so it's become a real difficult situation for states to come up with laws that actually make sense on the internet, and the Dormant Commerce Clause is just one way we get there.
So
Eric, if I may, would you just at least agree that the courts today, separate from what you would want them to do to go farther, courts today would find it unconstitutional for states to set a single one-size-fits-all standard that applies to intermediaries? That would be unconstitutional, whereas it's constitutionally much less problematic for states to go after individual users.
If they can do the proper geographic authentication, users in fact can respect state borders. Take a cyber harassment type of thing. A lot of times you've got a domestic violence situation, you've got a spouse, an ex-spouse is going after another ex-spouse. They know where the states they're dealing with. There's no question about that. They're using the internet as a tool to do that, but the geographic authentication is built into the scope of the relationship. For intermediaries trying to make matches between users, unless they have built-in geographic authentication into their system, doing that geographic authentication is expensive and still not very accurate.
Okay, David, last word.
I asked you about the Ohio bill. I mean, you said a constitutional one, but the Ohio bill, if it became law and you had an Ohio bully, an Ohio victim, and an Ohio ISP, the Constitution wouldn't have stopped them going after the ISP. Only 230 saves that ISP.
So I wanted to kind of take this out of the constitutional arguments. The only people who can make those constitutional arguments, if these laws were to come into effect, are people like Google, very large companies. In the US, there are probably over 30,000 infrastructure providers, the vast majority of whom are small businesses who don't have the resources to even understand the I don't even think the Supreme Court really understands the Dormant Commerce Clause.
I don't.
So this is just an illustration of how this creates a cost on small businesses and in fact doing business on the internet.
And again, I always find it frustrating when we talk about this, the stakeholders in this. The real stakeholders I wanna fight for are the companies that don't exist yet. And by definition, they're not around to go and challenge a statute. They simply are chilled by the behavior because, they don't know if they can even make a go of their, respective investments.
Okay, well, I'm gonna give you each a chance to give a bottom line takeaway here, but before I do, if we have any questions from the audience, any staffers wanna ask, questions? If not, we'll